The Delphi murders case shook the nation, and now Richard Allen has been found guilty. But could an appeal change everything? Let's talk about what happens next. Richard Allen does not have to do anything right now. In fact, the law in Indiana is a person does not have to file their notice of appeal until 30 days after they've been sentenced. So, and that makes so much sense, because could you imagine having to appeal before your sentence, literally looking at the judge and being like, hey, in case you didn't know already, you did X, Y, and Z wrong. And because of that, we're going to appeal to your bosses. It just does not a good idea to file notice of appeal before your sentence, because basically lets the judge know they were wrong. Could create a bias. I'm not saying a judge would actually do that, but it could. So in the aftermath right now, Richard Allen does not have to do anything. So if somebody's thinking to themselves, well, hey, he hasn't filed an appeal yet, he must not be appealing, we don't have to do that. I believe I read somewhere that sentencing has been set for December 20th, 2024. So 30 days after that will be the deadline for filing an appeal. Now, what could be appealed? Well, anything and everything could theoretically be appealed, but that doesn't mean appealing everything and anything is a good idea. Indiana has deadlines, they have word counts, they have page limits. Indiana Court of Appeals tries to get issues as concise as possible. In fact, we talk to judges at events, CLEs, legal education. The judges tell us, hey, we want our appeals to be concise. Pick your top issues and focus on those. We don't want rambling appeals. And just because there are page limits, just because there are word limits, doesn't mean you have to use them all. So while everything and anything could theoretically be appealed, generally attorneys pick the top arguments to appeal. Now, what cannot be appealed in this case? Well, in this particular case, there are some facts that are not in contention. The first fact not in contention is Richard Allen was at the scene where these girls were found. That's not for debate. He, in fact, called the police and told them, hey, I was there, and here's a time frame and all those other things. Richard Allen placed himself at that scene. And we also can't really argue, can't appeal the fact his car was also seen near the location where these girls were found. So he was there. There's no one's going to argue that he wasn't there. That doesn't mean you can't appeal. So there are, in my opinion, three rather big issues that the defense team can appeal in this case that should get some traction, if you will. Number one, the bullet evidence. The bullet evidence, in my opinion, is based on absolute garbage science. Trying to figure out if a bullet was discharged from a gun when that bullet wasn't actually fired through the gun, that is garbage science. Now, the state of Indiana had some people come in and say, hey, we were able to do it, and the defense brought people in and they said, hey, it's not good science. The reality is, this is kind of like a new frontier, or at least it's being developed. And the fact that the judge allowed defense to present evidence and the state present evidence, I think ultimately the Court of Appeals is going to say the bullet evidence is going to go to the weight, not the admissibility. I do not see the Court of Appeals kicking out the bullet evidence. They're going to say, hey, you know what? Defense brought in an expert, and the expert did a great job attacking the evidence. But ultimately, the jury chose to believe the state's version. And that happens. It's weight versus admissibility, and you see that so much when you're a criminal defense attorney. It basically says, hey, the Court of Appeals said, hey, nice try to trying to keep it out, but it comes in. I don't think the bullet evidence is going to go anywhere, but I think it was important that they attacked it. The second big thing, in my opinion, is the confessions under duress. I've heard descriptions of what was shown to the jury when they turned the cameras around and what Richard Allen was doing when he was in jail, and it sounds horrible. But the reality is jail is horrible, and people make confessions on jail calls all the time. It's an everyday occurrence in the world of criminal defense. We have people being arrested on weak evidence, and the officers put them in jail hoping they make jail calls because people love to talk so much and they get more evidence, and those calls come in all the time. I don't know how you can make a rule. I don't even know how a rule would be workable. Well, if a person's under duress in jail, their confession doesn't come in. I think you would see juries skyrocket, and that might be a good idea for some of these cases that are such weak evidence. But I don't know how the Court of Appeals can insert themselves into the hearts and minds of people on the phone in jail. It's such a regular occurrence. And if you've never been in jail, thank God. Jail is horrible. Just going to where the attorneys visit, it's depressing. It smells terrible. You're in cages. People are just locked away. Jail is horrible. And jail isn't meant to be fun. But, man, jail is terrible. And in the perfect world, in my opinion, they shouldn't put anybody in jail unless they have all the evidence against them. And then anybody who says things while in jail shouldn't be able to use against them because jail is horrible. But that's not the law right now. When people make jail call confessions constantly, people always think they're more clever than they are. And they're not clever. I'll use the fake name, Mark. They can never prove it back to me. You use the PIN number. They have your voice. They know what you sound like. Other witnesses, other people in jail heard you say it. Jail confessions come in constantly. I don't think this is going to come anywhere. I think once again, the Indiana Court of Appeals is going to say, wait, not admissibility. It comes in, and the jury got to choose what version of events they believe in. Now, the third and final most viable appellate issue, in my opinion, is the kicking out of third-party perpetrators. Now, I think this one is actually the winning argument. And the reason why is this guy's on trial for murder, and his defense found evidence, maybe not a lot, maybe not too much. Obviously, the judge wasn't convinced by it, but these attorneys found some evidence that pointed to Odinism, third-party perpetrators. There's even investigated by the police. There is some pagans inside the jail. There's just this evidence, even if it's just a tiny little bit, that kind of points towards Odinus might have had a hand in this. I'm not saying I believe that. I'm not saying it happened that way, but there is a tiny bit of evidence. And the judge completely kicked it out. The judge did not give the jury the opportunity to consider that. And I think that's problematic. The cases where I have found where third-party perpetrator defense was not allowed at trial was when a defendant was trying to blame a specific person. Hey, I didn't do the crime, Frank did. And the state of Indiana stands up and says, no, Frank was in jail. He couldn't have done it. And the judge looks at the defense. What's your response to that? Frank still did it. Well, I mean, the court doesn't have to put on false facts. They don't have to allow false narrative to come through. So they rightfully kick out evidence where it's impossible for a third party to do it. But I saw no evidence that it was impossible for Odinus to have done this crime. It was just maybe weak evidence. But the judge completely took that from the jury and didn't even give them the option to at least consider that. I think that is going to be the most problematic part of any appeal for the state of Indiana. And I think that is likely, if anything does, lead to a new trial. Now, the Indiana Court of Appeals has an option of saying, hey, you know what? You played it wrong, judge. You should have let that evidence in. But the other evidence was so overwhelming, it doesn't even matter because a jury wouldn't have found him not guilty. Now, that is the most hated of appellate opinions by defense attorneys because the Court of Appeals basically says that's impossible. The jury wouldn't have cared. How do the Court of Appeals know that? But it happens all the time. They simply say, hey, you know what? It was wrong, but it wouldn't have mattered. Conviction affirmed. That is what I dread if that happens in this case because I want justice for the families. I want justice for these kids, but I want justice done the right way. And something inside me just kind of says the Odinus stuff should have came in because if it came in and they found him guilty, he's done. But unfortunately, there is going to just be appeals, and I think that this might get retried. And that sounds horrible for the families involved. So in conclusion, if you've watched this far, please like and subscribe. Leave me a comment. I'll try to respond to all the comments. It's hard, though. I'm very busy. Most importantly, remember to always play the fifth.